Before we begin, I would like to acknowledge with sadness the passing of a very distinguished daughter of our beloved country, Dr. Linda Babulal. Many of us, myself included, would have wished to pay our final respects today. But of course, one doesn't have control over these things. And at this time, final rites are being conducted. So some have been forced to make the difficult choice of choosing between this ceremony and Dr. Babulal's farewell. But I would like to take this opportunity on behalf of myself, my immediate family, and of course the extended Judiciary family, to extend condolences to the family of Dr. Babulal, and to, of course, thank and acknowledge those of you who have come. Your Excellency, Mr. Anthony Thomas Aquinas Carmona, ORTT, Senior Counsel, former President, Honourable Attorney General, other members of Cabinet, and of the Parliament of the Republic of Trinidad and Tobago, Your Excellencies, Heads of Mission and representatives of the Diplomatic Corps, Honourable Justices of Appeal, Judges, Masters and Judicial Officers of the Supreme Court of Trinidad and Tobago, Judges of the Caribbean Court of Justice, Chief Magistrate and other magistrates, members of other superior courts of record, heads and representatives of religious bodies and international organizations, representatives of the legal fraternity, members of court administration of the judiciary, distinguished representatives of the public and private sectors, other specially invited guests, ladies and gentlemen. Here we are again. It sometimes helps to lighten the mood of a captive audience, I'm told, by starting a speech with a bit of humor. I suppose most of you will have heard and be tired of the old joke about Henry VIII saying to one of his wives, "I shall not keep you long." But perhaps after all this time, less well known and more apt for me at this juncture is the reputed reply of his last wife. I have a pretty good idea of what I'm supposed to do. I'm just not sure how I can do it any differently. However, I am privileged and honored to be given the opportunity to address you in my capacity as Chief Justice for what is now the 12th time since my appointment. That makes me the longest serving post-independence Chief Justice. I am aware that that fact alone presents challenges for some people, but we all have to suck it up and do the job we are assigned to do. As with many other things during that period, as Charles Dickens has said, it was the best of times and it was the worst of times. But as Chief Justice, I have had the privilege of overseeing, with the assistance of many of our stakeholders, the most expansive period of judicial reform in Trinidad and Tobago. As I have reiterated in many previous speeches, the implementation of these reforms has been hampered by both the lack of financial resources and lack of the technical capacity to fully effect the transformation of the judiciary into an institution that is relevant and responsive to the needs of our evolving society. All fundamental transformation requires three basic components: people, plant, and process, undergirded, of course, by appropriate technology. and I shall try to address all of those today. I want to start with people for two reasons. The first is that as Chief Justice, my only accountability after God is to the Constitution and to the people of Trinidad and Tobago. But getting people to accept change, even when everyone complains bitterly about the status quo, is often the hardest challenge of any leader. Change can be scary, especially when we have to leave our comfort zones and learn new ways of doing things. We can be made to believe that power we never had is being taken away, and in that regard, there is no profession, and I belong to it, but there is no profession that is more egocentric and tradition-bound than the legal profession. This organization comprises over 2,000 persons with complex interlocking functions. And much of the criticism, internal and external, comes from persons who have never managed anything bigger than their chambers, are not management professionals, do not respect other professions, and frankly, do not appear to comprehend that evolving technologies, including artificial intelligence, machine learning algorithms, are already beginning to displace us from some areas of practice, such as due diligence, contract review, and even divorce settlement, requiring lawyers to reskill and to relearn. Sometimes we don't appear to understand that law is practiced and adjudication conducted in a historical, social, cultural, and economic context, as well as a rapidly evolving and global technological space. I make no apology for my approach that in all of this, the most important people are not the lawyers or even the judges, but the people whom we serve. Hence, our theme of transformation for enhanced delivery. Why am I going there? It is because much of the vitriol coming at us and at the JLSC is about who gets elected for the bench and how and what kind of people and organizational structures are needed to support them. But interestingly, the last round of appointments to the High Court bench has produced an outstanding group of judges who have contributed in great measure to the increased productivity that we are experiencing. As I have intimated in an earlier address, I see no direct role in the recruitment process for the Law Association, partly to preserve the confidentiality of applicants, and partly because the Judicial and Legal Service Commission cannot be seen to abdicate or delegate its constitutional remit. However, the process does involve a written examination in which candidates are required to attain a minimum standard in all sections, and we do set the bar fairly high. Recently, the JLSC had to abort a recruitment exercise for the High Court bench at this stage of the written assessment that has been ridiculed in some quarters because no one met our stringent requirements in all of the sections. I want to emphasize that success or popularity at the bar, however that may be measured, is no guarantee of a successful transition to the bench. I can do no better than to quote excerpts from the report of the independent external examiner, who is himself a renowned jurist and academic, and I quote, "The third section of the examination evidenced a lack of critical thinking and legal analysis skills. Only 3 answers were structured in an acceptable manner, dealing with the issues presented in a sequential and orderly fashion. They also have weak writing and analytical skills, and the lack of these skills does not augur well for a successful career on the bench. Based on this performance, it appears that many attorneys at law do not keep abreast of recent developments in the law. The results of this examination emphasize the need for a greater focus to be placed on analytical writing and thinking skills within the legal profession. As a general observation, the performance of the candidates presents a strong case for the need for continuing legal education. We do have a problem. As goes the bar, so goes the bench. I pause here to remind you that continuing legal education has been a feature of this judiciary for at least 2 decades, as indeed has compulsory continuing education for practicing attorneys in Jamaica and other progressive jurisdictions as a precondition to the renewal of a practicing certificate. The Judicial Education Institute, now generally acknowledged to be the premier small jurisdiction judicial education institute in the Commonwealth, stands committed and ready to support and partner with the Law Association once it rediscovers its statutory moorings, so that the judiciary and the public will be better served, and we will have a better prepared pool of aspirants to the bench from which to choose. Because whether temporary or permanent, appointees will have to hit the ground running from day one, since they will be affecting lives, livelihoods, property, and families. This job is not about profiling in the media or storming big people party. Forgive me for speaking frankly when I say that if you are power or status driven, you could be as bright as you want, you're not suitable. That brings me to the other people challenge. That is that there is a malady that has infiltrated the psyche of our country over at least the past 2 decades, and which can best be described as a disdain towards institutions of the state and a general and overt hostility towards the occupants of public office. Today, we feel empowered as a people to tear down our leaders, the institutions they lead, and even those that we belong to as stakeholders. We lose sight of the fact that in doing so, we undermine our own legitimacy, weaken the society, while eroding our own independence and sovereignty. It produces an environment that breeds division, disunity, self-loathing, and the perpetuation of tribalism with all of its negative connotations. We in the judiciary, as a key stakeholder and one of the 3 arms of state, have not been immune from this assault. The issues we face have little to do with the publicly articulated disputes between judges, but speak to a general decay within the society as a whole, and one that is typified by a sense of entitlement, selfishness, and lack of faith in and respect for the institutions of the state. On the issue of loss of trust and confidence, let me say that I fully appreciate the sense of alarm and insecurity felt by the population about the crime situation. Many among us continue to view with consternation the reports of matters only coming to court after 10 or more years, of prisoners awaiting trial on remand for periods in excess of the sentences they would receive if convicted. And the judiciary is usually blamed as being inefficient. It is assumed that in these matters we are at fault. To the contrary, the judiciary does not determine when or who to prosecute, does not make a determination on what cases are deserving of plea bargain. It does not gather evidence or conduct forensic examination. Those responsibilities and attendant inefficiencies in the management of outcomes in the criminal justice system are outside the purview of the judiciary. I do not mention this out of a desire to cast blame. We understand that other stakeholders labor under similar financial, structural, and environmental constraints. This is rather a clarion call to deepen dialogue and constructive partnership in the interests of our nation. And yet, when reforms are proposed to address the malaise, what we get from some quarters is a series of reasons why they can't work. Well, today I am proud to tell you that many of the things that were greeted with derision and skepticism, such as maximum sentence indications, judge-alone trials, and criminal case management rules, are already beginning to bear fruit. Between the close of the 2017-2018 law term in July last year and the end of July this year, there has been a 43% increase over the previous year in dispositions of indictments in the High Court. We look forward to the imminent and complete elimination of preliminary inquiries once we can find the judges and masters to case manage them to just and effective disposition. The transformation of the judiciary for enhanced delivery is therefore a matter of the judiciary being resolute in the pursuit of its strategic objectives, whilst simultaneously resisting attempts at deconstruction of the fundamental institutions of the society and responding to a changing social and legislative environment. There are those throughout our society whose agenda is to break down those institutions that are fundamental to the cohesiveness of our society, and to do so with one goal: to further their own personal ideologies and political interests. What is lamentable is that despite statistics that show increased productivity across the board, and I will refer to them briefly later, the reality is that fact is now overshadowed by perception, influenced by political affiliation and its associated tribalism. This is aided by the abandonment of the Fourth Estate of its responsibility to educate and inform, or even to act responsibly at times. One must first inform oneself accurately before criticizing. Reliance on uninformed, so-called reliable but anonymous sources is hardly enough. We have a protocol and communication department that is willing to respond to any reasonable queries that anybody has, if you really want to know what is happening and why we do what we do. At the risk of criticism, of being accused of arrogance, I have to say I am too busy doing the people's work to keep replying to direct inquiries when they are based on false premises and often impertinent. So please, don't waste any of our time. The judiciary is engaged in meeting the challenge of implementation of procedural and substantive justice in an environment in which participants and commentators presuppose the existence of bias and accordingly see that bias in all things. There is a danger in judging people by your own yardstick. Uninformed and malicious comment doesn't help. We in the judiciary will continue to address the legitimate concerns of our citizens while maintaining our institutional objectivity. Permit me now to segue into some aspects of process and technology that will assist that effort. The systems that we are putting in place to transform the judiciary for enhanced service delivery are, as well, an attempt to transform our working environment to strengthen the institution that is the judiciary and to ensure that it cannot be undermined, usurped, or be subjected to the influence of a few. You will be seeing the montage appearing on either side. It gives you an idea of the kind of activity and stakeholder engagement that we have been actively engaged in. But this is little known. So I'll take the opportunity now to share with you, by way of a presentation, the initiatives that we will highlight to you by way of the short video presentation exemplify those attempts that we are making to improve efficiency and secure the independence of the judiciary well into the future as a fundamental bulwark and last bastion of independence and justice within the society.
With the judiciary's overall drive to improve business processes, several strategic initiatives were undertaken aimed at increasing efficiency and service delivery, as well as improving safety, accessibility, and convenience. Many of these services are IT-based. TT Gym is a bespoke case management information system being rolled out in all Supreme Court locations and all district courts. With TT Gym, you can search all information on cases by party, case number, and other means including homophones. With TT Gym, tasks are assigned to persons in set workflows, allowing monitoring of completion of tasks and of workflow. Judges, masters, and magistrates can each see their dockets and search any case in it to see all documents, the status, or any other information required. TT Gym can automatically fill and generate over 100 court documents. It provides weighting of cases and creation of statistical reports, and in the Children Court module and the Criminal Proceedings module, it provides for use of the International UNODC Code's criminal charges. TT Gym allows the court to better understand and control its workload and case flow and supports management decision-making. It uses a sophisticated electronic document management system for storage and digital signatures, as well as public access functionality. So combined with other judiciary solutions, it will provide greater access and ease for lawyers using the court. With TT Gym, cases, courtrooms, people, and other resources can be scheduled, and conflicts can be seen and eliminated. Court Pay. Court Pay will allow the judiciary to stop having to take cash and store cash. This will make our courthouses safer and help to eliminate errors and fraud. Launched on March 9, 2018, starting at the Family Court, Court Pay is an electronic system introduced to provide a safe and accessible, convenient means for the court to receive and pay out money such as maintenance payments, filing, and other fees, fines, lawyers' practicing fees, and other trust funds. Payments can be made using top-up vouchers, credit cards, links, and judiciary prepaid cards. Court Pay can be accessed via self-service kiosk at the judiciary, TT Connect offices, and on personal devices including cell phones. At the courthouse, payment will be possible at the counters for all payments, including filing fees, practicing fees, fines, and cash bail, using links, credit cards, top-up vouchers, or special reloadable judiciary cards. Online, attorneys will be able to file documents online using court mail and to pay the filing fee online using Court Pay. Users of the system will have access to convenient and flexible payment methods, be able to conduct business without visiting the court, and not need to have cash. Court Mail. Court Mail, a secure, efficient, and convenient way to communicate with our customers. This application is a welcome feature to our expanding e-services. This email platform is a simple, fast, and efficient communication between lawyers and the court. It enables the creation and perfecting of court orders and creation of notices electronically and virtually, and the sealing and stamping, dispatch, and storage without the need for printing the document. Court Mail was created in response to concerns expressed by our external stakeholder, the Law Association, and our own internal challenges. Therefore, we created an application that is uniquely ours by adopting best practice, which allowed for a more efficient way to move information seamlessly between judicial teams, the registrar, and attorneys. The first major deliverable was the creation of team email addresses to ensure communication with the right teams. Court Mail is live. Court Mail went live on Wednesday, 24 July 2019. It is a secure medium for electronic transmission of court orders and notices between the court and attorneys. It will provide the court with a record of what is sent and the customer with authentication that the document has been sent by the court. The benefits include improved communication between the court and attorneys. Within the judiciary, it facilitates document collaboration and alerts to all parties involved in the creation, perfection, and dispatch of court documents. It allows attorneys to send and receive electronic documents. It provides authentication of court documents to the recipient. Integrates with Court Pay, so attorneys are able to pay filing fees electronically. E-Probate. The first phase of E-Probate is an online search platform for attorneys to lodge probate searches. It states the date on which the search will be completed and sent to the attorney. It sets a time standard of 3 days for completion of searches, and over the year during which it has been in operation, the standard has been met. This has been made possible by the digitization of all probate records from 1902 to the present. This was an extensive exercise done by a team of ORTTs supervised by a member of court staff. Many of the records, which date back to 1902, were held in old fragile books and files. This made the completion of the necessary searches very difficult and slow, with delays stretching into weeks or months. With this platform, searches are requested online, done in order, and within 3 days. Phase 2 of eProbate provides for applications for probate of wills to be generated online by the completion of a series of questions in a decision tree. The responses to the questions complete fields of information in a document template and, where necessary, stops the user and points out that an additional requirement is needed or that the application cannot be made as conceived. An application is generated and lodged online for checking by the probate section staff. E-Services Dashboard. The e-probate services, civil filing services, court mail services, practicing fee payment, and judiciary card reloading will be made available on the e-services platform, which is being developed. It will provide the attorneys of Trinidad and Tobago access to services such as probate searches, probate lodgings, and civil filings through a web interface. This platform will integrate with Court Pay in order to facilitate digital payments where needed. To use the e-services dashboard, an attorney must complete the registration and verification process. To register, the attorney undertakes a 3-step verification process using a web form. After completing the 3-step registration and verification process, an attorney can log into the e-services platform using their BAN number or email address and password. Once the attorney is logged in, they can now access all available e-services dashboard services. Digital voice transcription. Certified transcripts are the official record of court proceedings. They are produced for, among other reasons, to review facts and submissions to arrive at judicial decisions, to have access to official court records for future reference, to provide for appeal purposes a written record of evidence submissions in the conduct of a trial, for legal publication, etc. Steps in transcript production: dictate audio into text using tools provided, edit transcript with audio to ensure accuracy with the recorded audio, accurate format, and proper use of punctuation. Transcript proofread with audio by head court transcriptionist or court scopist. Proofreader. Proofread transcript returned to court rapid text entry specialist to review with audio and make the necessary corrections. Transcript is certified before the registrar or justice of the peace as being true and correct. Advantages of using digital voice recognition software. Trained persons are able to dictate recorded audio at 225 words per minute, which is equivalent to real-time transcription. A court transcriptionist, electronic, currently transcribes at 60 words per minute. Hands-free transcription. There is a lower risk of developing typing-related ailments such as carpal tunnel syndrome. What's next? BailNet is a planned database of bail taken which details the surety used. It will enable searches so that surety accepted will have equitable value. It will speed up the delivery of service to the public. eProbate is being expanded to provide greater services to our customers. The first technology court is being designed and rollout of several such courts is planned. TTGM Family Court Module and Civil Court Module are in development. Cloud-based video conferencing, not only for remand, but for other appearances. This will enable better quality video conferencing. Recently, the incomplete video conferencing center at Golden Grove was handed over to the Judiciary for completion. These information technology-driven developments are part of the Judiciary's trust towards enhanced access to justice for the people of Trinidad and Tobago.
As you can see, improved service delivery requires major organizational and process reform. At the macro level, the creation of the Family and Children Division has now been followed by the proclamation of the District Criminal and Traffic Courts Act 2018, through which the Criminal High Courts and the District Criminal and Traffic Courts have now been brought under a single governance structure. The district courts, formerly called magistrates' courts, are now more closely aligned to their Supreme Court counterparts with the introduction of magistracy registrars and clerks of the court, as well as on-site court managers. This is in fulfillment of my promise to focus on the courts of summary jurisdiction, which are the face of justice for over 95% of our population. This will enable the district judges to focus on their core function of case management and adjudication, while all ancillary and supporting services, often referred to as case flow management, but which encompass everything from security to buildings to ICT and registry processes, are managed by trained professionals. The old linear, hierarchical, colonial-style management structure is gone for good. It is being replaced by a matrix or style organization in which key leaders share responsibility for case flow management, performance management, time and attendance management, planning, budgeting, court office functions, and tools of trade, technology, and space management. The TTGM case management information software that you've just seen, referenced, is just a part of our e-services suite that is already reaping benefits, as orders can move virtually through the courts for verification and perfection, and ultimately out to lawyers and litigants. TTGM, which is the product of our collaboration with the National Center for State Courts and the Nigerian Judiciary, is fast becoming the gold standard in the Commonwealth. We've had expressions of interest from Barbados, Guyana, the Bahamas, and as far afield as the African continent. As a matter of fact, I travel tomorrow to Zambia to sign a memorandum of understanding with their judiciary and the NCSC for the use of the platform. And any further refinements by any of the other parties to the MOU will redound to our benefit at no cost. The job of Chief Justice is not just being head judge, but the CEO of a large, dynamic, and complex organization that is mandated to deliver a variety of services. And all we ask is for you to understand the job before pronouncing on stewardship. Another major ongoing initiative is the build-out of the Family Court, which goes live in Tobago this month with a full formal launch to follow early next month. I have been dismayed at the perception in some quarters that the assignment of a judge to the Family Court implies a demotion or loss of seniority. In the first place, we only have one Supreme Court. Judges may be assigned to any division at the discretion of the Chief Justice and in the best interest of the judiciary. In the second place, judicial officers assigned to the Family and Children Division are required by statute to possess, in addition to the gazetted qualifications for appointment to the High Court bench, such experience, temperament, and qualities that suit them for appointment to that division. Only a special type of judge goes there. And it would be very short-sighted indeed if we thought that we could fix the crime problem in this country without fixing our families. As we say in the Children Court, it is easier to build strong children than to repair broken men. I don't want you to think that South Trinidad is being left out too. In fact, we are engaged in an extensive building program, and we have finally gotten cabinet approval to source funding for the San Fernando District Criminal Court, and we anxiously await the final go-ahead for the family court in San Fernando, which is long overdue. And I'm putting the AG under some pressure here. I see him nodding in the front row. We also expect to bring new court buildings online in Princestown and Arima. We are confident of our ability, once we are given access to funding, to effect savings and to deliver on time and within budget. Happily, I discern a growing realization from the executive of our ability to manage effectively. One example of what effective collaboration can achieve is the fact that we are now nearing completion of the judicial officers' quarters in Tobago, and you may have seen them on the montage. Even though there was originally no money in the budget for this purpose, we were supported by the Ministry of Finance in the environment of funds from areas where we were able to eke out savings through efficient management. I remain forever optimistic that this will soon lead to the full adoption of the framework for judicial autonomy that has been languishing for far too long, despite the absence of any known reasoned objections. Now, as you know, we have long since outgrown the Hall of Justice. Many of our support units are scattered all over Port of Spain in rented accommodation. And so we were thrilled to receive the news that when Parliament vacates Tower D at the waterfront complex, it will be handed to the judiciary for immediate occupation. This will enable us to retain the Hall of Justice with its cells and appropriate circulations for criminal, trial, and appellate courts, while fitting out 11 trial courts, 10 hearing rooms, mediation rooms, civil appellate courts, and judicial officers' chambers, along with supporting services and the JEI at the waterfront location. We expect to complete that move during this law term. It will also give us the opportunity to fit out the first of several fully equipped technology courts with state-of-the-art recording and presentation technology, including facility for virtual appearances. This is indeed an exciting time for the judiciary. Our only constraint is our ability to get all the people on board and trained in record time, especially the judicial officers. So I do need to sound a word of caution that due to attrition, promotions, and the need to restart the appointment process, the High Court will be a little undermanned for the first part of this year, but we expect to recover that ground eventually through increased productivity. In all of this, I don't want you to get the impression that this transformation is about us. It is about you, our customers. After all, the purpose of enhanced efficiency is better service delivery. So, as for an example, you would have heard about court pay, mainly in the context so far of maintenance payments, but it is much more than that. Our e-services platform is about making access easier for attorneys and litigants. We are marrying the buildings with appropriate technology and intensive staff training so that you will get a faster and more seamless experience. A lot of thought and work is going on behind the scenes. Some of the pictures appearing on the montage behind me speak eloquently to the energy and dynamism of our judiciary family. I wish I could have some of these young people speak to you directly, because this is what the Trinidad and Tobago judiciary that you do not see or hear is all about. It's about people from all walks of life, working hard to improve how we do what we do. It's your judiciary working for you. Why is the media not reporting this? Why are we focusing on Bacchanal? Contrary to the impression that is being deliberately propagated, we are not in a crisis or a shambles. Now, I have deliberately left the statistics for last because they only paint a partial, though important picture. But I'm duty-bound to report on them. But I wanted you to see that we are a vibrant, thriving, and rapidly evolving institution. And the statistics actually bear that out. As has been my practice in recent years, I will only give an overview and leave you to a more leisurely, detailed perusal of the annual report, if you so wish. In what follows, the comparisons are between the 2017-2018 law term and the recently concluded 2018-2019 law term. At the Court of Appeal, filings have been up 25% from 636 to 796. Dispositions were up 32% from 437 to 577, for a total clearance ratio of 72%. On average, 58% of matters were determined within 1 year of filing and 78% within 2 years. Civil High Court filings increased 16% from 4285 to 4967. Dispositions are also up a modest 4.5% from 3739 to 3898. The judges are working hard. I am told by the Statistics Department that the average age of matters now at the time of disposition is just about 13 months. Well, I already told you the good news about the High Court criminal. In keeping with the thrust to reduce the backlog, we have been up 43% in dispositions. At the Family Court, a total of 4,568 matters were determined, of which 44% or 2,021 were divorces, 31% were maintenance. We continue to make inroads into the backlog, with 75% of applications determined in less than 1 year from filing and 87% within 2 years. I spoke earlier of the importance of the family court to societal healing. Consistent with that philosophy is the wraparound service that we provide. We observed a 23% increase in matters referred to the Social Services Department for psychosocial intervention. Mediation is also an important alternative dispute resolution strategy, and we had 291 matters referred, 74% from judicial officers and the remaining directly from our intake officers. Our proud baby, the Children Court. As many of you are aware, the Children Court is a subdivision of the Family and Children Division. Operations were commenced in Trinidad in March 2018 and in Tobago in December of 2018. It is a problem-solving court whose primary customers are persons 18 years and under and who are involved in matters before the courts. It provides targeted interventions to address their needs with a focus on rehabilitation and reintegration of child offenders into society. For the 2018-2019 law term, which was our first full year, a total of 1,050 matters were filed, of which 51% were criminal matters, 36% children in need of supervision, and 8% and 5% respectively being brought by the Children's Authority or by private application. A total of 731 matters were determined, and for these purposes, a determination means that the matter was either closed, it was dismissed, transferred to another court, or the child would have received a custodial or non-custodial sentence and is in post-sentence monitoring. Probate. In case you missed it, there is some really good news coming out of the probate registry. Non-contentious probate dispositions are up 35% from 1842 to 2483, with an overall clearance rate of 61.5%. It was 47% the previous year. 82% of small estates are now being disposed of within a year, and 80% of large estates within 2 years. We still have to work on the outliers, but as e-probate reduces the number of queries, we expect the positive trend to continue. As those of you who practice in that arena know, a perennial complaint has been the inordinate length of time taken to complete searches in the past. With the introduction of e-probate searches, 97% of queries have met the time standard of 3 days. This is just one example of the power of technology to improve service delivery. So there you have it, ladies and gentlemen. I could keep you longer, but that would be cruel and unusual punishment. I hope you have been able to get a sense of where we are and where we are headed, and the optimism and the commitment that still characterizes this remarkable organization that I have the privilege to lead. All that remains for me to do this afternoon is to thank all of you who have contributed to the success of today's events. We were thrilled to be able to return to the Cathedral Church of the Holy Trinity for a service of divine worship, and we are grateful, as always, to the Dean and our Bishop for hosting us. It feels like coming home again after the temporary arrangements that we had to make last year. A special thanks go out to our guest speaker, Professor Rosemary Bella-Antoine, for her thoughtful and stimulating address. May I say, Professor Bella-Antoine, you've challenged us. And we hope that collectively, we, both bench and bar, will be able to take up that challenge and meet it. I was also proud and thankful for the opportunity to showcase our guest choir, the Port of Spain Youth Choir, led by Ms. Granderson. I hope that some of you who were blessed by their ministry will take some time to learn their story and to find a wherewithal to extend material support. Those are the kinds of efforts that we want to encourage so that we do not lose our youth. Thanks also go out to Commissioner Griffith and the TTPS who gave us a very smart display and injected a special feature this year with the horses. And of course, MTS, or security personnel, audiovisual technicians, and my deep, heartfelt, and personal thanks to those judicial officers and judiciary staff who have continued to support the vision, who have given their all, and have enabled me to deliver a positive report. And last but not least, ladies and gentlemen, thanks to you, our listening audience, whether you're here physically or present virtually, for the courtesy of your attention. This court now stands adjourned.
Protecting our people, bringing justice through our nation, standing firm while still being fair. We are your judiciary, with an air of understanding. We treat with respect each one we see.